New York City apartment building accident lawyer. Know your rights. Attorney Andrew M. Stengel. Living in a New York City apartment means trusting your landlord to keep shared spaces safe. When that trust fails, the consequences can be life changing. In fact, a broken stairwell railing, a malfunctioning elevator, or a poorly lit hallway can cause serious injuries in seconds. New York premises liability law gives tenants and visitors powerful rights after an apartment building accident in New York City. As a result, understanding those rights is the first step toward the compensation you deserve. What New York law requires of landlords in apartment buildings. Landlords in New York carry a non delegable duty to maintain safe common areas. That word, non delegable, is critical to understanding your rights. Property owners cannot transfer legal responsibility to a superintendent, a management company, or an outside contractor. Even when professionals handle repairs, the landlord remains personally accountable for building safety throughout New York. Courts hold that willful ignorance is not a defense. If a hazard existed long enough that a proper inspection would have found it, the landlord had constructive knowledge of the danger and a duty to fix it. Covered common areas include lobbies, hallways, stairwells, elevators, laundry rooms, and parking garages. Furthermore, this duty extends equally to tenants and their guests. Visitors, delivery workers, and emergency responders all receive the same legal protection as permanent residents. Additionally, building size and rental price do not affect the standard. New York courts apply this obligation consistently across all residential properties throughout the state. Common apartment building accidents that lead to lawsuits in New York. Certain conditions in New York City apartment buildings cause a disproportionate share of serious injuries. Broken lobby doors and defective vestibule locks allow unauthorized building access. For instance, that access can expose residents and guests to criminal attacks that a properly maintained building would prevent. Defective stairways are another leading cause of severe injury throughout New York. Worn treads, missing handrails, and inadequate lighting create dangerous fall conditions throughout the city. Fractures, spinal injuries, and traumatic brain injuries are common outcomes that require extensive and costly treatment. Elevator malfunctions carry equally devastating risks. Sudden drops, door closures on passengers, and leveling failures, where a car stops above or below the floor, cause injuries that can be permanent. New York City law requires regular elevator inspections by licensed contractors, and violations of those requirements become powerful evidence of negligence in court. Roof and terrace defects complete the most dangerous hazard categories in New York apartment buildings. Unsecured access doors, deteriorating railings, and failing parapets create conditions that lead to catastrophic harm. Property owners who know about these problems and fail to act bear full legal responsibility for what follows. How court records prove what your landlord knew about your apartment accident. HP proceeding records in housing court are among the most powerful tools in a New York apartment building accident lawsuit. These records include outstanding violations and detailed repair histories. Consequently, they establish a documented pattern of landlord neglect that is difficult to dispute in court. For example, a landlord who receives repeated New York City Department of Buildings violations for broken stairway lighting cannot later claim ignorance. Documented violations prove actual knowledge of the hazard. Therefore, when an injury occurs, those records often become the centerpiece of a strong lawsuit. That paper trail can make the difference between a modest settlement and a significant recovery. Moreover, HP proceeding records frequently reveal patterns of neglect extending far beyond a single accident. Prior complaints, unresolved violation orders, and court directives all expose systematic failure. In litigation, this history connects your injury to a broader record of deliberate inaction, strengthening your case considerably. Why you must act immediately after a building accident in New York. Evidence disappears quickly after an apartment building accident in New York. Building security cameras typically overwrite footage within 48 to 72 hours. Maintenance records can disappear before any investigation begins. Retaining an attorney promptly allows for immediate protective action on every front. Preservation letters go to building owners, management companies, and contractors, legally requiring them to retain all evidence. Investigators reach the scene before conditions change. Witnesses provide statements while memories remain fresh. Most importantly, early legal action prevents the evidence destruction that negligent landlords sometimes pursue in the aftermath of an incident. Beyond evidence concerns, strict procedural deadlines apply in certain cases. New York City Housing Authority tenants must file a notice of claim within 90 days of any accident. Missing that deadline permanently bars your lawsuit, regardless of how clear the negligence is. For private landlords, the statute of limitations is 3 years, but waiting is never advisable when evidence is at risk. What you can recover in a New York apartment building accident lawsuit. After a building accident in New York, injured victims can pursue compensation for all losses the negligence caused. Medical expenses, including emergency care, surgery, and long term rehabilitation, qualify as fully compensable damages. Lost wages also factor into the recovery, especially when serious injuries prevent a return to work for months. Furthermore, New York courts recognize pain and suffering as real and significant harm. Fractures, spinal injuries, and traumatic brain injuries carry lasting physical and emotional consequences. Juries in New York take these damages seriously and award compensation reflecting the full impact on a victim's life. Insurance companies representing negligent landlords often push for quick, undervalued settlements. Adjusters use recorded statements and rushed timelines to minimize what they pay. Speaking with a New York premises liability attorney before accepting any offer protects your interests and preserves the full value of your case. The law firm of Andrew M. Stengel, PC, holds negligent landlords accountable. Negligent landlords in New York count on injured tenants not knowing their rights. Our apartment accident lawyers pursue every available avenue: court records, DOB violation histories, maintenance logs, and expert testimony. We represent injured tenants and visitors throughout New York, from New York City to every part of the state. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.